Hey guys, let's talk about breaking news in the Smithline and Bianco cases versus Manson. Both of those are in federal court. You probably already know that Smithline's attorney moved to withdrawal yesterday. That's the same attorney that represents Esme Bianco. Motion to withdraw was short, as it should be. Just cited the undue, unreasonable difficulty that the attorney says he's having in representing the client, some unspecified breaches of the retainer agreement, and asked to be relieved of representation by the court. That once you appear in court for the person, you can't leave and stop representing them until the court lets you out of the case. So it is kind of a big deal to take on a case for somebody in court because you can't simply withdraw yourself out of it. The court has to give you leave to withdraw. A lot of speculation about that, but some of the meat on this thing is blown up in the Bianco case because Smithline was due to have her deposition taken a few weeks ago. We didn't know whether it happened or didn't happen, but it didn't happen. And in fact, it was moved out a couple of weeks. And that's where we start to see some of the action on this case. So the attorney for Smithline in the Bianco case has moved to quash the subpoena, saying that she shouldn't be subjected to this upcoming deposition because she doesn't have a new lawyer yet, and he's moving to withdraw. And he says this: prior to the original date of the deposition, that was the one that was going to be in mid-August, August 17th, counsel for both parties agrees to extend the date 2 weeks until August 30th. Pursuant to that agreement, the defendants issued another subpoena commanding her, Ms. Smithline, to appear remotely on the 30th. However, the relationship between Ms. Smithline and her counsel then irreparably broke down, resulting in the pending withdrawal of Ms. Smithline's counsel from her own case against the defendants. So then Eltwanger, of course, tells Manson's attorneys and said, hey, will you guys agree to put this deposition off because I'm trying to get out of this case? And they said no. He also says he wants to allow her the time to secure adequate representation before the deposition will be rescheduled. And normally when somebody's withdrawn out of the case, the new counsel will come in and it'll be substituted rather than hopefully a period of time where you're not represented at all. That's not impossible, but if you're a litigant in federal court, you really don't want that to happen unless you really mean for it to happen. So Eltwanger notes that the current subpoena would place an undue harm on Smithline in that it would force her to testify at a deposition either unrepresented or represented by counsel who's already filed a motion to withdraw from representing her. Now, when you file a motion to withdraw, you're not relieved from obligations in the case, so I don't know that that argument by itself carries a whole lot of weight. But we'll just have to see what the court says about that. But where the spiciness occurs is in the exhibits to this thing. So this starts off with an email exchange between Manson's attorneys and Smithline and Bianco's attorney. And Smithline's attorney says, as we discussed last week, we agreed that in order to seek additional continuances of Ms. Smithline's deposition, I would ultimately need to provide to you and the court a written assessment from Ms. Smithline's psychiatrist that she is unable to participate in litigation due to the current status of her mental health. For reasons which I am ethically required to keep confidential, I cannot provide this written assessment. So I'm going to have to withdraw as counsel for Ms. Smithline. Interesting. Then Manson's attorney says, hey, you haven't given us enough information to evaluate this motion, including whether Ms. Smithline consented to the withdrawal. Regardless, the issue will not be resolved before Tuesday's deposition, and Ms. Smithline is required to appear. We're going to keep it at the original start time. And then they note that they don't think they've been produced the documents that they should have received. Smithline's attorney comes back and says, you know full well I can't ethically provide more information to you regarding this type of motion than I've already provided. Per what evidently seems to be your request, I will tell the court my motion that you're opposed to my withdrawal. I'm copying Gene as your position on this issue will also be attributed to him and his firm, and he has a right to know the course of action you're requiring that I take. So Eltwanger's accelerating, escalating this thing a little bit. And yes, Ms. Smithline consented to my withdrawal, he says. Howard comes back and says, will Ms. Smithline be here in person for her deposition on Tuesday? Will her delinquent document production be implemented today? Howard, as you know, I filed a motion to withdraw as counsel on August 27th. I'm writing to ask your agreement to take Ms. Smithline's deposition off the calendar and allow her the chance to seek replacement counsel. If you won't agree to do it, I'll have to file a motion for protection because the court has not yet ruled on the motion to withdraw. Let me know if you agree. Howard says, no, I'm not taking this off the calendar. Okay, Howard, do you confirm you oppose the motion? Howard says, what are the grounds? She was supposed to appear 2 weeks ago from her duly subpoenaed deposition, an appearance confirmed on multiple occasions by you. On the day before appearance, you represented she'd flown to the United States to obtain emergency psychiatric care and could not appear. Rather than forcing you to make a motion for protection at that time, we made a professional accommodation to you to continue the deposition date. You promised nonetheless, immediately complete the full document production, representing that you already had the responsive documents in your possession. Apparently that representation was not accurate, as the promised production was not made. You also promised written evidence from the treating professional of her medical inability to have attended the deposition. You failed to provide that. Finally, you said Ms. Smithline would appear for deposition tomorrow. You've ignored multiple requests seeking confirmation about that. So yes, we oppose, and we ask this entire email be included as part of your motion. So Ellwanger fights back and says, hey, I made a motion to withdraw and you're asking me the grounds for that. I'm clear on that, right? Howard raises his tone of voice a little bit and says, you represent two different claimants who have conspired to create a false narrative, which is why the deposition of your client Smithline is so critical in the case brought by your client Bianco. We believe your attempts to avoid Ms. Smithline's deposition are a ploy to preserve Ms. Bianco's fake claims. And Ellwanger says, cool theory. Anyway, do you oppose the relief we're seeking? Yes, in red. We oppose the relief and ask this entire email be included as part of your motion. So there's the nasty exchange between the attorneys on this as it's heated up. I think the deep takeaway out of this is there is an issue going on with Smithline. And of course, there are a lot of things posted online all over the place. Some things she's posted, some things other people have posted that that go toward what her mental state is. What has she said? What has she not said? I don't think there's any faking there that she's in a fragile mental state. And it's unfortunate this litigation is playing out in public like it is for somebody in that state. I know you don't have to be sympathetic to her if you believe that she made it all up. I'd get all that. But still, it's a human being we're talking about, and this looks like it's a pretty bad situation. So I hope something happens between these people that's a little bit behind closed doors to get this thing moved on, even if that's just taking the temperature down on this and getting new counsel involved. Now, having said that, I respect Manson's position and the position of his attorneys that there are all these cases, right? And Smithline is a material witness pretty much for all of them. And you can't just pull a witness out of the mix when it becomes inconvenient to you so that you don't have to deal with what they may say that may be detrimental to all these other cases. So they're right to push this issue. It's often the case that when an attorney's trying to withdraw, the best thing you can do is just get out of the way and let that happen, because then you're left with somebody maybe who doesn't even have a lawyer. Plus, eventually the person's going to be able to withdraw anyway, so why would you be fighting over it? Here, the situation is a little different because of all the connected cases. If it were only the one case, I think it would be well-founded to say, look, I need to get out. Let's just put discovery on a slight pause, long enough for the court to have a hearing on my withdrawal, and probably new counsel will be in by that point. But when you have all these other cases, I think Manson's point becomes a little more relevant, in my opinion, even if not in the primary case. So that's what's happening. It's a pretty nasty situation developing there, and I hope the litigation works out eventually, some satisfactory manner for the people involved, and the truth comes out, and really that no one's damaged any more than they already are going through this process. Thanks.